in essence, it is whether or not the conviction is safe. I mean, that pretty much is the test of the CCRC. And that reflects what the Court of Appeals say. So it can come from a different angles. For example, a lack of disclosure by the prosecution to the defence, something that was so important that if the defence had it, it would have fundamentally changed.
But you're not
the nature
alleging
of the case.
that,
That's
are
not fresh
you?
evidence.
And the Court of Appeal has rejected this twice, hasn't it?
I'm sorry?
I mean, the Court of Appeal has rejected this twice. Have you got anything new,
Once.
any
It
new
rejected it
arguments?
once. But the full hearing that took place, Lucy Letby did not succeed. I agree with that.
So have you got
And
anything
if you
new?
notice something, like for example, the Birmingham Six went before the Court of Appeal, I think 3 times before their conviction was overturned. So as I say, things happen, things develop, things are argued.
Why did you take this case?
Mainly because I can see that there's a potential miscarriage of justice here. This actually reflects, the Lucy Letby file reflects another 3 cases. There are currently 4 nurses serving life imprisonment for harming patients. And she's the latest one, but each case mirrors each other in the way that the prosecution have run the case and put the matters before the jury. And I represent also Ben Geen, who's one of the other nurses that has been convicted. And it seems to me, certainly from my analysis of Ben Geen's case, that there were some serious concerns in relation to how the evidence was handled and put before the jury.
I mean, the problem in all these cases, and certainly in the Letby case, is that the case against her is largely circumstantial. There's no direct proof of her directly harming these babies.
That's correct. No one saw her do anything harmful.
There is one baby where it suggested that it had bruises, I think baby O, and that there was evidence of the baby being abused, and the suggestion that Letby was the only person who could have done that.
Well, I mean, again, one of the concerns that I have, and there's many concerns in relation to this, is these assertions that were made in relation to who was on duty, when they were on duty, and when things were meant to take place. But also, what we do is, and it's understandable that often the media takes selected parts of news items and that becomes the story, when actually we don't hear about the contradictory evidence that went before the jury as to who was where and what they were doing. Now, I'm right at the start of this process, and it seems to me certainly that there are thousands of pages I need to read and get my head around. But straight away, it seems to me that there are a number of serious problems, as I say, and I can go through each one of them if you want and slightly expand on them. I'm not too sure how much I have to do that, but there's issues in relation to statistical evidence that was not called and put before the jury, and let me just touch upon that. The prosecution's case at trial, like it was in the previous 3 nurses' cases, is that there's a spike in unusual activity. Either patients have died or patients have suddenly become ill. And this particular nurse here, Lucy, was on duty at the time. Now, not engaging with statisticians and not looking at comparable other units and not looking at the many, many problems we know that was occurring in this unit, one cannot make with any form of reliability that assertion. And it concerns me that no one's actually done a proper detailed analysis. They've simply just stood up and said, this is what's taking place.
But isn't the problem, Mark McDonald, that this case wasn't built on one piece of evidence alone? You're right. No. It wasn't built on one statistical presentation. I know there are questions about the time period or the way those stats were presented. It was a very carefully built case which had a lot of different elements to it. And so by identifying only that or questions about the insulin or the way that those tests were done, you are doing what you are, I suppose, suggesting is where these mistakes are originally coming to light. You're picking out one element and trying to unpick it. And actually, that's not how these cases work. They are very complicated. And the parents of some of the children that are involved here, they say, actually, this is misinformation. It's not how the court case was built. And if you weren't there, doing this, indulging in this kind of conversation is actually just very dangerous.
Well, let's just unpack that whole question that you asked. What I said is, by way of an example, I'll just pick out one. And I did say that there were a number of different elements to it. There was the nature of the expert evidence that was called before the jury, and whether or not that should have been allowed to go before the jury, given the nature and the reliability of that evidence.
Yeah, I understand all this, but the fact of the matter
sorry, I was trying to answer that first
well,
question.
no, but you're making. I just want to make a general point.
Yes, of course.
There was a long trial, wasn't there?
Yes.
And there was a subsequent trial, at
Yes.
both of which she was found guilty.
Yes.
And the defense had the opportunity to produce expert witnesses. It didn't take it. Isn't that how our criminal justice system works? It's an adversarial system. You put a case, and at the end, a jury reaches a verdict.
Yeah, no, I agree. And it's worked that way for centuries. But things go wrong, Adam, and you know that. You know that there are miscarriages of justice. You know that people are tried before juries, that evidence is presented, and time after the verdict's happened, and maybe years later, people realise, in fact, things went wrong in that trial. Now, I've been able to identify a number of things that have caused me concern in relation to the trial and what went before the jury. And again, as I say, and as I started right at the beginning, this mirrors other trials that happened where serious concerns have been raised. One of those cases, one of those nurses, is before the Court of Appeal next year, challenging the whole insulin issue, having been referred from the Criminal Cases Review Commission back to the Court of Appeal. It's not straightforward. You can't simply say, well, she had a trial, she was convicted, that's it, that's the end of it. Because what you wouldn't find then is people like the Birmingham Six, the Sally Clark, the Guildford Four, all the great miscarriages of justice that we've seen in the history of the United Kingdom have happened post-conviction. They've all gone in front of the jury. They've all had prosecutors present the evidence. They've all had all the closing speeches and all the expert evidence give evidence, and they've been convicted, and yet later they're found to be innocent. So my job is to analyse, and as I say, I've already identified a number of areas of concern, and to take that forward to the Criminal Cases Commission and to ask them to refer it back to the Court of Appeal. And that's what I'm doing.
Just want to ask you, do you think you've got any chance here? Because as I understand it, the criteria for the Criminal Cases Review Commission to make a reference is fresh evidence. And you're going over the old evidence, aren't you?
The test is very similar to that of the Court of Appeal. In essence, it is whether or not the conviction is safe. I mean, that pretty much is the test of the CCRC. And that reflects what the Court of Appeals say. So it can come from a different angles. For example, a lack of disclosure by the prosecution to the defence, something that was so important that if the defence had it, it would have fundamentally changed.
But you're not alleging that, are you? And the Court of Appeal has rejected this twice, hasn't it?
I'm sorry?
I mean, the Court of Appeal has rejected this twice. Have you got anything new, any new arguments?
It once, but the full hearing that took place, Lucy Letby did not succeed. I agree with that.
So have you got anything new?
If you notice something like, for example, the Birmingham Six went before the Court of Appeal, I think 3 times before their conviction was overturned. So as I say, things happen, things develop, things are argued, and if you can show that a conviction is unsafe, then the Court of Appeal would agree with you. And at the moment, or in the last argument, they obviously didn't succeed. That doesn't mean I'm not going to succeed.
Can I ask you finally, Mark McDonald? There is this story in the Sunday Times today. It's obviously an incredibly emotive issue, but this is the first time some of these families are speaking publicly. Yes. And this article starts with them saying, we want to say, shame on you all. That's the message from those who are calling for the release of Lucy Letby. What do you say directly to them?
Oh, they have a right to be angry. They have a right to be angry. Of course they do. And upset. And if the defence team are correct and no crime was actually committed here, then their anger needs to be pointed in a different direction.
Mark McDonald, thank you very much for joining us on the programme today.